Will I really be a witness in this case? Reporters hate being the story. Reporters, we're there to report. I did an interview with Colby Ryan last week, and it was odd for me to be answering the questions. We want to be there to report. We're there to observe. I'm here in Arizona as a representative of the people, you could say. The people in Idaho, those of you who can't make it to court, it's my job to bring it to you. The freedom of the press. I am allowed to come and cover news events for you. So anytime a reporter is inserted into a story, much less a murder trial, it can become awkward. And because of that, originally, I had said here, I believe, that I didn't think it mattered because I hadn't been served a subpoena. And if I wasn't planning to go to court, maybe that would be true. But if I walked into the court, from what I understand, Lori Vallow could say, Your Honor, one of my witnesses is here watching, and there is an exclusionary rule. Exclusionary rules apply to all witnesses. They cannot watch or listen to other people's testimony because it could affect their own testimony. And assuming the judge allows Lori Vallow's objection to me being there, I would need to leave. The prosecution has already filed a notion to preclude, meaning exclude, all of Lori's witnesses. She filed the paperwork, her motion, late past the deadline. So the prosecution says they should all be thrown out. The judge has not ruled on that yet. In order to kind of protect myself after consulting with our attorneys, we came up with this that I filed last week pro se, meaning on behalf of myself. I worked with an attorney to write this. Know that I did not write most of this, but it sounds very smart. Nate Eaton, appearing pro se, files this emergency motion for protective order requesting the court strikes his name from the witness list of the defendant Lori N. Daybell, pursuant to Arizona Rule of Criminal Procedure or any other applicable law or rule as follows. I have learned that I have been identified as a potential witness by Miss Daybell for both this case and the other case, the one involving Brandon Boudreaux, which will happen in a few months. I'm a reporter for East Idaho News and have no firsthand knowledge of information regarding the crimes of which Miss Daybell has been accused. My involvement in any matter related to Miss Daybell has only been as a reporter. It is my understanding that by simply listing me as a potential witness, I can be barred from the courtroom during Miss Daybell's trial. This seems to be a clear attempt by Miss Daybell to use the role of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. Such an effort clearly interferes with my First Amendment rights as a reporter and the First Amendment rights of my employer to view and report on the events of the trial in the same manner as any other member of the media. Thus, listing me as witness results in the harm far outweighing any claimed usefulness. There is no legitimate usefulness to listing me as a witness. Further, that risk of harm cannot be eliminated by a less substantial restriction of discovery rights, as it is not the disclosure of my identity that is harmful, but the abuse of the rules of criminal procedure to list me as a witness in order to interfere with my constitutionally protected rights and duties. Therefore, I respectfully request the court deny or strike Ms. Daybell's attempt to list me as a potential witness. Signed by me. We sent that in Wednesday or Thursday. Then we got a hold of a very smart media attorney here in Arizona who has done work for media all over the place. And we have not reported this yet, but on Friday, late, he filed this motion on behalf of me, asking the judge to hold a hearing before, if there's any chance that I'm going to be struck or that I'm not going to be allowed in, we are requesting an in-person hearing with the judge to discuss this issue. Here is the motion. Again, it hasn't been reported yet. It was just filed on Friday evening. I don't know if I'll read through the whole thing. It's 5 pages, but Non-parties East Idaho News and its journalist Nate Eaton filed a supplemental memorandum in support of Nate Eaton's emergency motion for protective order. As the court knows, the case in this subject is the subject of widespread public attention, both here in Arizona and in Idaho, where the defendant, Lori Vallow, was convicted of murdering her 2 children. As the court also knows, Ms. Daybell has criticized news coverage of the criminal proceedings against her. Nate Eaton, the news director of East Idaho News, has reported on Ms. Daybell's criminal cases in Idaho and Arizona and intends to attend and report on the trial in this matter, scheduled to begin with jury selection on March 31st. Ms. Daybell has included Mr. Eaton's name on her list of potential trial witnesses, but has neither contacted Mr. Eaton about any relevant information he may have, nor issued a subpoena. Mr. Eaton did not witness any of the events at issue in this case. His only connection is his coverage of the criminal proceedings against Ms. Daybell. Mr. Eaton, acting pro se, filed the emergency motion on March 25th, noting that his inclusion on the witness list, quote, seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. East Idaho News now files a supplemental memorandum to further explain why Mr. Eaton is entitled to this relief that he seeks: an order striking his name from the witness list, or at a minimum, exempting him from the exclusionary requirements. And then we go on to say that Ms. Daybell has no right and has not met the strict requirements under Arizona law and the First Amendment to compel me to testify. In order to do that, she would need to serve me a subpoena and require that the subpoena has to be supported by an affidavit setting forth certain information, like the information Lori seeks, a certification that she's attempted to get that information before sending me a subpoena, the identity of the sources, things like that. Second, and then that goes on. And then second, preventing me from attending the trial would violate my right and East Idaho News' First Amendment right to report on criminal procedures. Simply listing me as a potential witness who might be called to testify does not provide a basis for excluding me from the courtroom. Mr. Eaton has not been subpoenaed, and as explained above, any such subpoena would be void. But even if Ms. Daybell could issue a valid subpoena, barring Mr. Eaton from the courtroom during her trial would violate his and East Idaho News' First Amendment rights. It goes on to say at the end, for the foregoing reasons, well, actually, let me read this paragraph. If this court prohibits Mr. Eaton from attending and reporting on this trial simply because she inexplicitly listed him as a potential witness, Ms. Daybell will have succeeded in performing an end run around two of the most sacrosanct First Amendment principles. She will be excluding a journalist from a criminal trial and effectively gagging that journalist, with this court's help, from telling the public what transpires during the trial. The court should not stand for such misuse of its procedures. We then say, for the foregoing reasons and for the reasons set forth in the emergency motion, we request that the court grant the motion and issue an order striking my name from her list or exempting me at a minimum from the exclusionary rule. East Idaho News also respectfully requests that its counsel be provided the opportunity to appear and be heard before the court issues any order that would bar Mr. Eaton from the courtroom. Tomorrow I plan to go to the court. My attorney has told me I can be in the courtroom during jury selection. It's not part of the official trial, and I will not be hearing other witnesses. I'm hopeful that in the morning the judge rules on this and my emergency order, and that he says I'm struck from the list and we don't have to talk about it ever again. That is my hope. I hope you hope that too. There have been reporters forced to testify in other cases. It might, the issue is here, I have nothing to say. These crimes happened in July of 2019. Lori Vallow, I did not cover this story until December of 2019. So I have not witnessed anything, and all of the information I know has been gathered in news gathering from sources, from my own research, from investigations, my own doing, not about this case. So we'll see what the judge says. Thank you all for your concern. That's what I've been asked the most, and hopefully I'll have a report to bring you tomorrow night that I can be in the courtroom.